All right, our last speaker before lunch is Mr. Mark Lees. He's an attorney, but he's still a good guy. He's a partner at the law firm of Seyfarth Shaw in Chicago. And Mark is a labor and employment lawyer specialized in occupational safety, health, and personal injury litigation. And Mark has done a lot of work for over the years with the NDA directly, so he knows our product and he knows our industry.
Good morning. Actually, it's good afternoon, and this is a terrible time right before lunch. I know people don't like attorneys in general, and then to hold you here for your lunch. I'm going to move my program along, but it is a pleasure to be here, and I see a lot of friends out in the audience. And by the time we're done, you're going to have a very good idea of what your potential civil liability is. That means OSHA penalties against the company, and criminal liability. That can be against the company, that can also be against you. And we're going to get through this, and I'm also going to talk about some of the latest developments that are out there with OSHA. I got to first make sure I know how to operate this. I just press down. Look at that. That's me after multiple face peels. Anyway, and I'm going to the Notre Dame game tomorrow, and I'm hoping we don't lose another one. For those of you who are Notre Dame haters, it's probably a great year. Anyway, I'm the only attorney in the country whose last name can also be pronounced Lies. And you can do that if you want. It's okay, fine, half the world does. I know that some of you in this room are shy. So if you have a question, you want to ask it and you're shy, just say I had this friend who looks like me and talks like me, and ask the question for your friend. Now, if you don't have any friends, I can't help you, okay? But I'll try to answer your questions. I also try to lighten things up because I use stories that'll stay with you. The PowerPoint is just to kind of organize us, okay? I'm going to give you some stories. And I like to throw in things to lighten it up. For example, we're in Miami. Does anybody have any idea where that came from? Well, that's actually the name of an Indian tribe that is now extinct. And there's only 10 words left in their entire language. And they lived up on the shores of Lake Okeechobee up the road here. And Miami means big water. And where did Florida get its name? Well, you've all heard of Ponce de Leon. He was on a quest to find the fountain of youth. I don't think he did because his grave is back in Spain. But when he was here, he pulled up on the shore, and it was flowers and trees and everything else, and he said, wow, look at all the flowers. So they called it Florida. So that's where that comes from. Kind of figure a few of these things out while we're at it. So what's the kind of background where we are right now with OSHA? Last year, the president said, I'm going to leave it all on the ground right now. I'm going to leave it all in the field. And he has done exactly that in the OSHA area. We're going to talk about a lot of new agendas that have just come up in the last few weeks. OSHA is very, very aggressive. Those of you who deal with them all the time realize that. I know that there's liaison groups here with the association with Washington going in to meet with them and trying to get OSHA to understand your industry. But they don't understand your industry. They don't understand Subpart T in my view. They think that every day you should be doing an engineering survey. They don't like the idea of tripping structures and people going into the structures and getting them prepped to do that. They don't know what overstressing structural members means. I have all kinds of citations on that. I don't know what overstressing means. I guess that means you touch the metal and you stress it. So there's a fundamental issue there. What else is going on with OSHA? Over the last 4 or 5 years, all the baby boomers are leaving. They're leaving in droves. So those of you who deal with them know the area directors are gone. The compliance officers that you dealt with, they're gone too. What does that mean? Brain drain. The people who knew something about what your regulations meant and knew what to do are no longer there. There's also, when you try to ask them, can you give me a little assistance, give me some guidance, you get a blank stare because they do not have the experience. They're not bad people, they just don't have the experience. So you, in fact, are training the next generation of OSHA compliance officers and area directors. So let's talk a little bit about, assume this works, good. This is what we're going to cover. And just to go back to the beginning, when OSHA first started, all you were was responsible for your own folks. So if they had your baseball cap, your shirt on, that was fine. And that was plenty, because you have to worry about the general duty clause, and we're going to talk a little bit about that. And you also have to worry about 30,000 regulations under 1926 that apply to you. So I've heard the speakers here earlier before say, you're never fully in compliance. You never are. If you went home and memorized all those regulations, you would not be in compliance because the judges may reinterpret them differently, and the general duty clause is always creeping out there. For example, there's a lot of activity now with OSHA with cell phones. Okay, they're looking at it very closely right now. They've already put out guidance, not only driving, but cell phones as a fire and explosion hazard. Those of you who are going to fly home are going to hear the little Samsung warning, right? If you have a Samsung Sultan series, do not turn it on in the airplane. Well, think what that could happen if you have somebody, an employee who has one of those on your job site and they're in an area that's rated for a potential fire or explosion hazard. So cell phones are on the screen. It's changing all the time. So that was bad enough, having to worry about your own employees. Now what OSHA did, and those of you who deal in this area know that they created the multi-employer worksite doctrine, which basically says if you're on a worksite and somebody else's employees are out there, you can be cited for their employees, even though your people are not doing the same work, are nowhere in the area, and you didn't supply the equipment. For example, if an outside contractor comes out and brings scaffolding out, and the scaffolding doesn't, and you've hired them to do some work, masonry type work, they bring their own scaffold out and it doesn't have fall protection. If you're the controlling employer, you can be cited, even though you don't know anything about scaffolds. You've never been on one, you're not a mason. Because OSHA will take the position if you fall into any one of those 4 categories. You create the hazard, you send somebody to go work near it, your contract says you have to correct all the hazards, or you're the controlling employer, that means the general, you could be cited. This also has teeth in it, not only for citations, but criminal liability. If one of their employees dies, and they can prove there was a willful violation of a regulation, and they can prove you had knowledge of it, you can be indicted for that. And they're being very aggressive. The idea is to make you in charge of not only your subs, but if you're a sub, your sub-subs. So what, let's see, is we going here right? There we go. So when you're out on a site, who are you? Look and see what your status is. And the critical issues are at the bottom. Make sure you have a good contract, okay? Who's responsible for safety? Who's doing the JHA? Who's providing the PPE? Who's providing the training? Who's doing the walkarounds? Things of that particular nature. And you need to walk around too and be writing these folks up. Don't exercise control over means and methods. If you see them doing something wrong, stop the work. Don't tell them how to be an electrician. Don't tell them how to operate their equipment. That's what you're paying them for. As soon as you start telling their operator how to operate the equipment, you become a direct employer. You're controlling means and methods. And finally, obviously, we want to stop imminent danger. You see one of their people up on a leading edge, no fall protection, you see them doing something they shouldn't, stop it immediately. As soon as you take them away from the hazard, it can't be an OSHA violation. To have an OSHA violation, you have to have an exposure of an employee to a hazard. If they're not exposed, it's not a violation. So, what are some of the aggressive things they're doing? PPE. They go after people with lead. They really don't like lead a lot, and they went after a contractor out in Pennsylvania who was doing a bridge job. They were renovating and demolishing part of a bridge, and they went in the enclosure and they found many employees wearing the respirators on top of their heads, and since most of us don't breathe through the top of our head like a dolphin, there was really no reason to have the respirator on top of their heads or hanging around their necks. You turn it upside down, lead particles came out. Some of them had beautiful beards. They looked like Charlton Heston in the 10 Commandments. It was fantastic. But OSHA didn't like it that much, and they said, you know, you guys are pretty sophisticated. You know what you're doing with lead. So here's 276 willfuls, $5.3 million. Maybe that'll make you think a little bit about your lead program. So if you have a situation like that, it can be bad. The general duty clause topics are a number of the issues, but I'd like to just drill down on one particular, heat illness, because I have limited time and I want to make sure we cover everything. Heat illness. This is a big topic. Some of the folks that you're hiring to work for you are the millennials. They've never had to do hard work before, and I've got some of them. I have 6 kids. If you go to Notre Dame and you don't have a lot of kids, they take your diploma back. So I have 6 kids, okay? Some of them are millennials. They've never had hard-working summer jobs. They all want to be computer programmers, okay? Nothing wrong with that. You put them out on one of your job sites, and it's a hot day, and it's humid, and they don't know anything about heat illness, because heat illness is not only the conditions inside this room, which is the temperature and the humidity, but it's also what I'm doing. If I'm sitting in the front row here, I'm generating 1 kcal. If I start doing jumping jacks, or I'm carrying a jackhammer, or I'm climbing up a ladder, now I'm generating a lot of calories, and my internal body temperature is heating up. And if it's humid outside, what happens? I don't cool off. My sweat doesn't cool off. So then what happens? Well, we go through the 4 steps. We start out with the heat rash. That's where your clothes are too tight. You get the little bumps around your neck. The sweat can't get out. Second one is you get the cramps. Oh, I got a cramp. You're not getting the nutrients to the muscles. Third one is you're getting heat exhaustion. Now you're sweating profusely. Your body is working as hard as it can to cool off. And the fourth one is what? Heat stroke. You stop sweating. Your blood turns into a solid. You don't cool off anymore. I tried a case for 18 days in Chicago last year involving a CTA driver, or CTA laborer, who was working outside, 70 degrees in the morning, got up to 84 degrees in the afternoon. It was raining. And things didn't go so well for him. He said he had cramps. We took him to a place, and in the process of doing that, he went through the stage to heat exhaustion, and then he went to heat stroke. And he died the next day, 108 degrees. So we tried that case, and it's going to be a test case. In fact, when your body temperature gets up that high, we couldn't even do an autopsy because your internal organs liquefy. The cell structure breaks down. So it's nothing to fool around with. Make sure you've got people out there who have the first aid cards from the Red Cross, your supervisors who understand that. Water, ice, Gatorade. Be careful about Gatorade if people have diabetes. The sugar will put them into a coma, so have Quench. But it's a serious, serious issue. These are some of the other topics that are there that you need to be aware of, and I can certainly discuss any of them with you that you wish. Okay, we've had some new changes. In the old days, you had to call OSHA within 8 hours when you had a fatality, but only with a heart attack if the employee was doing strenuous work. Now it's all heart attacks. So you need to call them. That may generate an inspection. The one that is really kicking up a lot of interest is the 24-hour rule. If you have an employee who goes to the hospital and is hospitalized for treatment, not observation, you have to call OSHA in 24 hours. Okay, and that will probably generate, in some cases, an inspection. Another one is amputations. You got to call them within 24 hours of the incident. By the way, if the amputation occurs more than 24 hours after the accident, if the hospitalization occurs more than 24 hours after the incident, you don't have to call them. But there's a big argument now about what amputations are. In the case of a finger, it doesn't have to be the bone. It can be the pad of the skin. And then loss of an eye, that's not metal in your eye, that's not acids, there's no eye there at all. This is generating 20 to 30% more inspections, and so you need to be inspection ready when you call in. One thing that employers do, by the way, is OSHA will send you a form called an RRI, Rapid Response Inspection, and they want you to report online. Be very careful when you fill that out and you send it back in again that you don't make admissions or you don't speculate about the accident, because what they can do then is they can come out and they use that as a format and they ask questions and they start issuing citations. So be very careful when you respond to the rapid response investigation or inspection form that is online after you call them. Okay, the record keeping rule, this is big. We've all known for years that you have to keep the OSHA 300 log. And the OSHA 300 log is a mirror looking back at you. These are my injuries, these are my illnesses. They're only when they get to a certain level that they're recordable. OSHA thinks that companies have been intimidating employees not to report injuries or illnesses, so they don't go on the log, so OSHA can't see it. So they've thrown out some brand new rules, and by August 10th, of this year, you were supposed to have a revised anti-retaliation rule. And in there you were basically, and they take a shot at mandatory post-accident drug screens. They don't want you doing them anymore, unless you have reason to believe that drugs was involved or were involved in the injury. Now, unless you're clairvoyant, you're not going to know that. So that's one issue, and that's an important issue because you want to do an investigation right away. You want to find out if drugs in fact were involved or if there's a hazard and if you have to correct the hazard. And in some states, if there's drugs involved in the injury, there is no workers' comp liability. So it's a powerful tool. So that's the first one. And as we know, 20 to 25% of all your employees today are under the influence of drugs or alcohol. That's just the way it is in our society right now. And some of the marijuana that's out there that Bill Clinton didn't inhale, that was 2%, is now up to 40%. And some of those brownies that they make that have killed some children because the kids don't know that it's laced with marijuana, now they have warnings on it, are over 50% when they boil the stuff down. It's dangerous. Don't let anybody fool you that it doesn't cause permanent brain damage. So they jumped down on that. The next thing they jumped down on was immediate reporting of accidents. And most of you have a rule that says you must immediately report an injury or illness. And now OSHA's taken the position, well, that could be retaliatory if you punish an employee because they didn't report immediately. So now they want you to change your policy to say the employee can report the injury when they reasonably believe they were injured. So in the meantime, there may be a hazard, you haven't had a chance to investigate it, the evidence is gone, things of that nature. Third thing they took a shot at is incentive programs. If employees get bonuses or compensation is in any way derived from the DART rate, days away from work, restricted duty, or transfer, OSHA looks at that as to say that, well, that's going to also intimidate employees because they don't want to lose the prize or the bonus or the compensation, so you can't have that. They rolled this out, and within a very short period of time, they were sued in federal district court down in Chicago. And I checked on the case yesterday because OSHA backed off and said, okay, rule's effective now November 1st. So you still have a little bit of time. You got a couple of weeks. It's all briefed, and they're waiting for a decision from the court to see whether or not this rule survives. But if it does survive, you're going to have to go back and you're going to have to look at your drug and alcohol testing policies. And by the way, it does not affect DOT testing. They can't interfere with that. It does not interfere with a drug and alcohol testing policy that you've collectively bargained. That's interfering with the National Labor Relations Act, and they can't interfere if there's a work comp law that says that you have a right to do this. So there's certain exemptions that they can't get their hands into anyway. So let's see. I'm going to try to move along. Here's also what we're going to do for the first time. People are going to have to file your logs electronically with OSHA, and they're going to be made available to the public. This is part of the transparency, like this podium. I usually, if I'm doing really badly, I hide behind the podium, but I can't here. It's transparent. So what they're going to try to do is depending on the size of the company, if you have 250 more employees at a workplace, you got to file everything, the 300 log, the 300A, and every incident report. If you're 20 to 249 in hazardous industries, which you are, so if you have 20 people working at a site, one of your sites, you're going to have to file the 300A form, which is the annual summary. And then obviously they can get them during inspections. This is going to be a nightmare because you're going to have to strip off personal identifiers of the names of the employees because of HIPAA, the employee privacy statute, federal statute, new obligation for employers. So look carefully, track this. We've already sent out, I know we've sent management alerts out to the association. I think they're going to put an article in, but we'll send, as soon as we get any further guidance on this, we'll let you know, but the compliance officers may start showing up, assuming we get this guidance very shortly thereafter. So let's keep rolling because I have 7 minutes, okay? And I want to stay on task here. Okay. Okay, new penalties, okay? The last time OSHA upgraded penalties was 1986, and they're trying to catch up to the EPA. So on August 1st of this year, they said, well, we're going to jack them up, okay? And they did. And by the way, for a repeat violation, for those of you who don't know that, if you get an OSHA citation and they come back in 5 years, anywhere in the country, at any job, and they find substantially similar conditions, you potentially can get a repeat violation, which potentially could cost you $124,000. So the lesson is, after you get a citation, just because it has the American Eagle on it doesn't mean it's true. Challenge it to see if it really happened. Challenge it to see if the regulation is correct, and don't take citations that you shouldn't because it goes on your track record. And if you get enough of them, then you jump up to the category of willful. And then willful violations potentially get you into the criminal area. And one of the things we don't want to go is get into that particular area. So new penalties as of August 1st. Some people are getting sticker shock when they get their OSHA citations. Okay, GHS. We know all about GHS, the globally harmonized system. And I'll go to the last slide there. Oops, I went too far. Does that go back? Yes. June 1st of this year, you are supposed to have your entire GHS program up to speed. That means you got all the new safety data sheets, we don't call them MSDSs anymore, and you trained all your employees, and you had all the labels up, and you rewrote your program, et cetera, et cetera, et cetera. Hopefully you all did that. If OSHA comes out now to do an inspection and you don't have a current safety data sheet for chemicals you're using, you can be cited, except if you show reasonable diligence. So what are you going to do? If there's a chemical you're using and you don't have a safety data sheet from the manufacturer or from the distributor, be sure you have an email that goes to them and says, where is it? And they've created a safe harbor. They will not cite you if you show reasonable diligence to try to get the safety data sheets. Native language requirements, big deal. You have very diverse workforces. They will come out and they will bring interpreters and they will ask the employees if they understood the training that you're providing to them in English. Or if you've translated all your training into Spanish, they will say, can you even read? And if they can't read, you don't have any training. So any certifications you have are potentially false certifications. Employee literacy challenges, we have citations now from OSHA that say that employers' policies have too much information. TMI for the employees. They can't understand it. Plus, we have in Chicago a 70% dropout rate in high school by graduation. So we are unfortunately turning out functional illiterates that can't read the program. So a lot of employers are dumbing them down. And that's why we're using a lot of pictures. Okay, pretty soon we won't talk anymore. We'll just use pictures to communicate with each other. Criminal law liability. This usually gets everybody's attention. If you kill an employee now, and it's a willful violation, and they can pin it on you. You were the management person. You knew it, and you said, go ahead and do it anyway. That's a willful violation. That's a potential 6 months imprisonment in the Federal Correctional Center, and a $500,000 penalty against the company, $250,000 against you. The good news is, under the law of every state in this country, since you're an employee, and you're working in the scope of employment, your employer has a duty to defend you, to hire competent counsel and defend you in the case. Now, if you lose, they don't have to pay the penalty. It's against public policy to reimburse you for killing another employee. Obviously, that makes total sense. This isn't the whole picture, though. In September of last year, an attorney with the Department of Justice in Washington, D.C., last name Yates, Stephanie Yates, came up with an idea and said, we're not going to fool around with 6 months imprisonment here. That's a misdemeanor. We're going for the big ones, the felonies. And we're going to be looking during OSHA inspections to see if employers lie to us. We're going to look and see if they have gun-decked or pencil-whipped training records. That's a false government document. Those are 5 years. They just nailed a guy for fall protection. He was lying during an inspection. He met with OSHA 4 times, and each time he told them that he had provided his employees with fall protection. He got indicted 4 separate times and convicted 4 separate times, $5 years each, more than $5. So it's more important than ever during OSHA inspections that you know exactly what you're doing, and the reason I have Miranda warnings in there in red is because they don't have to give you the Miranda warnings when they come out and there's been a death. They don't have to tell you that you can incriminate yourself because they have no arrest authority. So and we're going to cover in just a second here because I have a little over a minute to do what you need to do during an OSHA inspection. When they show up, ask them why they're there. If you called within 24 hours or 8 hours, you know why they're there and you know you're going to get inspected. Have your programs and policies ready to go. Looking professional. Have your point person ready who's not going to volunteer and make admissions. And then be sure that you tell your employees what their rights are. OSHA will not. They don't have to. We're all presumed in this country to know our rights, and if you don't know them, then you waive them. So OSHA has a right to talk to every one of you and your employees, but you have a right to decline for no reason. Don't have to give any reason at all. You can end the interview at any time. You don't have to sign a statement. You don't have to be tape recorded. You don't have to be photographed. And if you want someone in there with you, you have a right to have them in there with you. And if OSHA says no, then you don't have to go forward with the interview. And if they say, I'll get a subpoena, you say, great, because at that point in time, you're entitled to have an attorney. Now, there's a big deal right now about statements. The compliance officer will write down part of what you said, not everything, part of it. And then at the end, they will tender it to you and say, I'd like you to sign this. No obligation to sign it. If you do sign it, you better make absolutely sure that everything on there is correct, because it could be a false statement. And you better ask them before you sign it, you say, I want a copy right now. Because if you sign it and they take it, and then you say, I want a copy, they'll say, sorry, can't give it to you. It's part of the official file, which is very disingenuous. Also, don't fall into the latest thing where they say you have to be interviewed in OSHA's car. You're on a work site. They say, no, you got to get in my car and be interviewed. This has happened twice to clients of ours. And they've gotten in the car, and the OSHA has taken down the statement and handed it to them. And the employee has said, I don't want to sign it. And OSHA's told them, you can't get out of the car until you sign it. Did you ever hear of something like that? It's called false imprisonment. As I say, things are kind of the Wild West out there. So I have 28 seconds left. I said I would get done within the half hour. What's the takeaway here today? There's a lot of new stuff coming up. Keep track. Go to the OSHA website and see what's up there before November 1st on this program. Make sure that if you have to send your logs in, you start thinking about how you're going to send your logs in. Make sure your GHS program is there, and I can't emphasize enough the multi-employer worksite doctrine. It's expanding and expanding and expanding. And with that, I will take questions. I'm down to the last 59 seconds. No questions. Unbelievable. No questions? Oh, way in the back, yes.
I really don't have a question, Mark. I just wanted to comment that it's always such a pleasure, okay, to hear your speeches.
Yeah, I'm the original good news guy, okay? I'm the good news guy. Anyway, just wanted to share that with you. Oh, there's another question, yes.
When you talk about treatment, being in the hospital, admitted to the hospital, how do you define treatment?
Okay, medical treatment. So if the employee goes to the hospital and the doctor says, I want you to sit there and see how you're doing. Let's say they got exposed to carbon monoxide, and after a while it goes out of your system. It just does. You leach it out. And then they let you go. You're fine. If they give you aspirin, at a regular strength aspirin, that's fine. But as soon as they say you're admitted, that starts the 24 hours. Or the doctor walks in and says, I'm going to give you some medication, at prescription medication, or over-the-counter medication at prescription strength. Now they're getting medical treatment. And now the 24 hours runs. But remember, if that doesn't happen within the 24 hours after the incident that got them there in the first place, don't have to call them. If they get badly injured and they have stitches on their finger, and then a week later the doctor says, I got to amputate it, don't have to call them. The amputation happened more than 24 hours after the incident. And again, unless you really like calling OSHA, I'm sure I would kind of check it out a little bit before I call them up. In this rapid response form, I've seen clients send those in, and it looks like a treatise. It goes on for pages and pages and pages, and it doesn't have to. All it has to say is, Mark Lease cut his finger, went to the hospital, and had stitches. And then it says what happened. You don't have to go into detail. He put his finger on a blade of a machine. That's it. What's the cause? Under investigation. Send it in. You don't have to do a core dump and provide them with the basis for giving you citations. Did I answer your question? Any other questions? Yes.
Mark, maybe for the benefit of the non-Americans here, you could quickly describe the general duty clause,
yes,
competent person rule,
okay,
and engineering survey.
Good. Okay. And again, I'll be quick on this. In federal court, they have a series of lights. The green light means you start. The yellow light means you got 5 minutes. The red line means you stop. The microphones go off and the judges leave. Okay? That's the way it works in federal court. Okay. If there's no specific regulation for a hazard, OSHA can still cite you under the general duty clause. What do they have to prove? They have to prove a hazard. They have to prove that it's recognized. What does that mean? That means the National Demolition Association in its publication says this is a hazard. Or it's in your own programs that says this is a hazard. And then they have to show that an employee was exposed to the hazard. That's all they have to show. So what does that mean? That means you have to keep current with what is going on out there. I already talked about heat illness. That's a hazard on your work sites. You need to keep current with that. The arc flash, arc blast, NFPA 70E, when you have potential for arc flash. So that means you have to keep current with that, and that's going to be add-on to your specific programs for lockout tagout and your specific programs for confined space entry. It is not a regulation. It's the general duty clause. It's a catch-all. Competent person. We have a concept in construction about competent person. That does not mean that, gee, he's a pretty smart guy, okay? Competent person has two heads to it. One is they know the regulations relating to your industry. The second one is they have the authority to stop the work. And since you're in the construction industry, on your sites, you must have a competent person. Now, they don't have to be there at all times. If you have multiple jobs and they're not complex, they can travel between jobs. But OSHA will show up and say, I want to talk to the competent person. And if everybody goes, who's that? They get an impression right away. And obviously, your competent person should be your really expert person out there, because they need to understand the hazards, and they need to have enough nerve and get up there and stop the work if they need to. But those are two concepts that are in our law here that you don't find. By the way, if you think our system is bad, I was reading about a case in China where there was a safety violation and some employees were killed. The plant manager was prosecuted. He was convicted. He was executed, okay? There's no appeals. And they don't tell you the date of execution. They come to the cell and say, come with us. And then after you're executed, you never return to your family. Whatever you were disappears, your remains. So we're not quite there yet. I don't think we'll ever get there. But it's a little different situation. And you better vote on November 7th. Your politics are your own business, because if we have 4 more years of what's here, it's not going to, as Mike Kasman pointed out, the exposure levels never go down. They never take regulations away. They always become more stringent. Why? Because the regulators have to have job security. Once you meet the PELs, they've got to lower it so they have a job to keep. They've got to keep lowering the levels or putting out no regulations. I'm being a little bit facetious there. It's a lawyer joke. Anyway, does anybody, I haven't heard any lawyer jokes either. People usually throw those at me. Any questions? Great program. Thanks for having me. Enjoy the rest of it.